Oh, I bet.
I wish I had battery, because I could be, if someone does, in the market event. If someone does send out someone does, I want you to move my phone. Yeah, I've got a little bit of extra much. I might have a look. I might, you know.
It's like that. I've heard it on firms a bit about like the Brexit, like they're not the questions. Years to design it. Planning for it. It's pretty much
The problem with like the funny thing is, it's like they do the thing of like there's even more staff in the building, and like, but that doesn't seem right.
Because you sent all the nurses back to you.
Yeah, but they did an amazing thing, like you know, to kind of see off the regional thing, and they actually have the plan nurses that they're fine in the Brexit.
Just everybody else.
You're alive though.
It's like
Knox.
You should also ask it. It's not going to be fair.
I wasn't ready to go.
I mean, in fairness, like most people have I think you almost close to
you just have to introduce yourself.
If you want to sell.
That
way, because otherwise what you do is you get it, like, how do you want me to introduce you? Go for it, like,
I got a point.
so,
But he's looking at me backwards.
yeah, that's all. He's actually that's statues, but obviously that's like the must be like being person in the art school. That's probably the easiest bad.
Drink something, we'll get back.
Oh,
Oh, no, I know. I'll keep an eye on. They've been really good. Like we've had 2 sets of tea without the tea bags. Any time around now. Good question.
What's the student?
Castle here and then Alice and everything. And yeah, so good. So yeah, and then here. And then just go up this here street.
So I think you guys did anything like that.
I only, so it has to go in. I'm really sad. And everything is also so open right here, and every like every time I listen, very flexible. They go to just a tiny circle around. Yeah, actually, kind of do face and travel so much. I just wanted all of my belongings in the office. Friends' options.
No. I read your one.
Hello,
Oh.
sorry, I was not here. I thought you were talking to yourself. And I saw you were this is your gesture.
Yeah, I'm talking to myself. That's my thing,
Sorry. I just think I was gesturing.
I can't hold it. I'm my basically friend Johnny.
I'm sorry.
You should be. Also, can I sit next to you?
Yeah,
Especially allocated seats, especially designated. Are you going for dinner?
No, I might have to get back.
All right. Right. No. Well, if you want to, you can do No, I don't think so. Well, so far, let's see what she says.
Thanks.
No worries. This is next. To say something like that. Every corporate.
Great.
Right, so before we begin, I'll just explain what this roundtable session is. First of all, thank you to everyone for sticking around for the last session today. This one is to kind of invigorate a little bit more, get a little bit more energy in before we start tomorrow with more panels. We're having a roundtable session based on question time. I'll be your David Dimbleby. We have several members of staff from the University of Liverpool. We also have Dr. Triestino from University, also joining us. Professor Tzanakopoulos from the University of Oxford sadly couldn't be with us. He had to get back to Oxford, where we sent his apologies. So this format will quite literally mirror question time. We'll ask some questions of our panels, and we want you as the audience to raise your hand at any point, and I will get Yvonne to either bring the microphone to you, or if you're comfortable enough in having a loud voice, just shout out your question, but only when I come to you. I think that pretty much sums up the format of the debate. So on our panel we have, as I said, Dr. Kanstantsin Dzehtsiarou from the University of Liverpool. We have Dr. Knox from the University of Liverpool as well. Dr. Mariniello from ILHRU University, Dr. Greg Messenger from the University of Liverpool, Dr. Schwöbel-Patel from our department as well, and finally, joining us in place of Tzanakopoulos, Dr. Anna Marie from the University of Liverpool. So without further ado, I will start with our first question, which is, to each of our panel, how would you define your research interests? Is this area of international law or human rights currently in crisis? So, to make things easier, I'll start with you, Anna Marie. No pressure.
So I broadly research in the area of international criminal law, international humanitarian law. More precisely, I examine the complexities of prosecuting armed groups before international criminal courts and tribunals. So at the moment, of course, ISIS is before, and so that has been taking a considerable amount of time. In particular, ISIS being a transnational terrorist group or a transnational armed group, its organizational structure is quite different to armed opposition groups that we saw emerging in the 1970s, 1980s, the early 1990s. So my research draws on organizational studies as well by Max Weber, the founding father of sociology, and also later writings of Memorial Dream and Ekaterina Stepanova, to really look in depth at the organizational structure of these groups, and as a result, examine the application of international criminal law to them. So my argument is that not all armed groups conform to this clear-cut hierarchical command structure, where it's very clear who the commanding officer is, who's the mid-ranking officer, who's the subordinate. My view is very much backed up by the organisation studies that is wrapping with that. These groups are very, some of the more contemporary art groups are very much network based, and that is not quite clear cut how they're structured. As a result, they're able to operate in multiple jurisdictions across the world, and it's not clear cut who is wanted, who to do what within the group. So it's not always clear, ultimately, how, what my argument is that it's not always clear how international criminal law ultimately applies to these types of groups. So I think perhaps you could say that international criminal in particular is the crisis at the moment. Actually, prosecuting international criminal court last April released a statement that she will not be able to, for the time being, pursue an investigation and any subsequent prosecutions against members of ISIS because of their serious and state statute, and also any attempt by the Security Council to refer the situation to the ICC has failed. So within my own research, I look at all those different competing debates and dilemmas. And
Thank you. Dr. Mariniello.
Yeah, start with the killer question. Well, I find my research, let's say, in the relationship between international criminal law and more widely international criminal justice and human rights. I'm interested in this relationship because I thought in the past that I think that it's quite a paradoxical relationship. Why paradoxical? Because at the same time, human rights play a very ambiguous, ambivalent role in the application of criminal law, in particular international criminal law. Ambiguous because at the same time, human rights constitute the so-called shield and sword function in the application of criminal law. Particularly when we are discussing about very serious crimes like genocide, war crimes, and crimes against humanity, we can see how international criminal law has been interpreted, conceptualized by the majority of academic literature as an instrument for the application of the fundamental rights of the victims. And we go back to the presentation in the panel before. This had, I believe, a strong impact on the fundamental rights of the suspect and the accused within international criminal proceedings. And this is let's say, the main focus of my research. I try to analyze the impact that this narrative is, that I defined before, victim-centric system in international criminal justice has on accused rights. Let's say, limitation or derogation to fundamental rights, which would be unacceptable at domestic level, are considered desirable at the international level on the basis of the seriousness of the crimes committed. So, yeah, it's in crisis. Second part of the question, I already answered so far. I mean, it's very difficult, I think, relationship, particularly at three different levels, definition of international crimes, sentencing, sorry, procedural guarantees and sentencing, but I think I will come back to this.
Thank you very much. Okay, so, well, very briefly, but I'm interested in theory of international law, and I use World Trade Organization law as a laboratory. So, it's basically, the WTO is essentially a laboratory price for international law. You have detailed rules, relatively compulsory dispute settlements, you have relatively decent compliance. It's an area of law that if you don't live in a war zone, affects your day-to-day life more than any other. And the relevant EU bits are just copy and paste jobs from WTO law, all the different trade agreements, all this sort of stuff. So it means that we can use this as a way of having like fun discussions and analysing different problems. So that's sort of the main sort of focus, I suppose. And then if it's in crisis, so the WTO, if we stick with that, the WTO has yet to conclude around successfully since, well, essentially in any meaningful way since creation of that one document. Does this mean it's in crisis? I don't know. I can't help but feel that international economic law in particular, language of crisis is used very effectively as a stimulus to encourage agreement by parties on certain issues. So we say that there's a crisis and we've got to push these things forward because we have a will slow down so we need to encourage growth, and they essentially goad states into concluding things that they might not otherwise want to conclude or might not be in their best interests. Or elements of those states might not be in their best interests. So, but aside from that, I don't know. I mean, there's plenty of trade law going. Everyone's having discussions about TTIP, CETA, EU, Singapore, DLR, CAFTA, all these different free trade agreements. The EU, which, let's not forget, is nothing special, it's just international law, and it's actually just international trade law. So, you know, nominally crisis, in practice, probably not.
Well, it's going to be last. Nope. So I have a few more minutes to prepare while everyone else is talking. So I have, unlike everyone else, my researching tests are much less specific and precise because I'm a shallow thinker, so I just run around looking at things to research. But broadly put, I work in kind of critical theory of international law, and I have two particular interests, which are the relationship, historical and contemporary, between empire, imperialism, and colonialism in international law on the one hand, and law and social change, what we can see on the other. That ends up involving quite a lot of distinct international legal regimes. So I would look at trade law, like financial institutions, law and use of force, in the contemporary scene, and then kind of historical acquisition of territory and things like that in the past. In terms of then thinking about crisis, I don't necessarily have any areas that I focus on being a crisis, but one of the things that I would say, particularly in this kind of line of the relationship between empire and international law, is that a lot of the contemporary crises that we see in their relationship to international law stem from historical problems linked with colonization and decolonization, and are linked also with contemporary power relationships which might be characterized as imperial. So I guess one of the things we'll get into in this particular question is the role that international law is playing in perhaps perpetuating those crises, and to what degree international law is useful in preventing.
Yep. I have a question to ask. Are you broadcasting?
Yeah.
Okay.
But we still want you to be controversial.
Okay. Right. My area is the European Convention on Human Rights, like the Strasbourg Court and everything is connected to it. I try to make sense what they're doing there. It is hard sometimes. I used to work with comparative law and how comparative law is applied by the European Court of Human Rights, consensus stuff, etc. But I'm tired of it, and I try to stay away from it as far as possible. Now, crisis. No, it's fine. It is actually fine. The United Kingdom might leave at some point. The European Court of Human Rights might be in crisis because of some perceived lack of legitimacy. The prisoners' voting saga is in full blow. Theresa May just said recently that, let's leave something. Well, we can't leave the European Union, we shouldn't leave the European Union, but let's leave the European Convention on Human Rights. It's easier, cheaper, and quicker. All these unelected judges, etc., etc. So, like, there are quite a few issues, and you know, like you saw the game recently between England and Russia. I'm sure, like, it was a very interesting game, and but Russians and British, they are not always on the opposite sides of the spectrum. In prison voting debate, they are very big allies. You know, like they're trying to say that the European Court of Human Rights is a bunch of hounds, and they shouldn't, or like the member of parliament of this fantastic country said, it's a kangaroo court that shouldn't actually tell us what to do. And therefore, this is some sort of crisis. No, I don't think so. Well. So no, everything is fine. I'm sure that the United Kingdom will stay in the European Convention on Human Rights. There will be some tensions, but I'm positive. I'm optimistic.
Thank you, Christine.
Have to follow that. Kangaroos, clowns, football, you can score.
All the books.
Yeah, so I have published in the areas of global constitutionalism, global governance, critical pedagogy, international criminal law. They all seem like different areas. And what sort of combines my interest in them, and I sort of tend to change my opinions on this daily, is at the moment I'm interested in how the rule of law is evoked in all of these discussions, and particularly how these are all combined by a sort of marketization of international law. That's what I'm really interested in at the moment. So I'm really reading lots of really interesting literature on marketing and branding, which is so much more interesting than international law, I can tell you. So yeah, a political economy perspective on international law is sort of where I come from, and whether all these areas are in crisis. I think I would be more interested in how crises are rhetorically evoked, and particularly how crises are rhetorically evoked in a sense of seeing the discipline of international law and its institutions as an area of limited resources. And if you see it as an area of limited resources, then crises can, and the evoking a crisis can be key in the decision making of how resources are allocated.
Thank you. I can't get on my box, that's all. That gives us a great overview of your areas of research interests, and I think you touched upon a couple of areas that we will definitely come back to. I already see a hand raised by Ben. Yes, did you have a question?
Yeah, just sort of picked up on the theme there from Greg and Christine on the sort of the use of the language of crises rhetorically, and Greg's observation is that maybe this use of crisis language is used as a stimulus. I was wondering whether anyone had any observations across different fields on when and why the language of crisis is used by institutions, by international lawyers.
Okay, so the language of crisis. Does anyone want to come back on that? Okay.
So as a stimulus. So yeah, I think that's probably what this conference has been about. So I'm at the moment interested in international criminal law and how victimhood is evoked there as a crisis for humanity. And that means it's a stimulus not only international criminal law is, and there are a few presentations on international criminal law, so a few of you are researching in that area, is always considered as this young discipline, but in its sort of short lifespan, it has managed to produce several institutions, a permanent court in The Hague, many researchers, many different centres which focus on the area. So by speaking about war crimes and crimes against humanity as a crisis, which needs to be dealt with in an international legal language, this has acted as a stimulus in many institutions and in many ways. So definitely.
Sorry to jump into your discussion. I think that the European Court of Human Rights is a little bit too chill about, too cool about all this crisis. They don't even see any crisis around them, and everything is business as usual. You know, when the United Kingdom again says that we are not going to implement this and that and this and that, so it is a crisis in my eyes. No, the European Court of Human Rights keeps doing. Maybe that's the right way of approaching the situation. Just forget about it and it will go away at some point. But maybe the modus operandi of the courts should somehow reflect the negative vibe from the contracting party, because there is only so much space that one court can kind of back off. You know, so maybe the courts and the the different institutions, they need to listen to the language of crisis. This is the microphone is ours. So.
So I think, so I think just building on what Christine said and this kind of idea of crisis and stimulus, one of the things that crises are very good at is, and this is something that Charles points out, is there a way of trying to carve out, say, exceptions or developing new legal arguments by saying we're confronting something which is really serious, which is unique, and that something has to be done about it. Therefore, we need to engage in this new form of legal reasoning. So it's productive, new forms of legal reasoning. One of the ways in which that's very common, right, is what you will use in the outcome of the crisis to say this thing is completely different, there are no analogs to it, so things have to change. So a good example would be, say, the stuff around ISIS and the discourse around the idea that this is a completely new set of laws. Fighting against non-state actors is not new. Fighting against non-state actors happened under colonialism, it happened before then, it is a very historically common thing, but by the construction of this argument around crisis and about it being new and distinct, there was this attempt to expand the power of the international state apparatus and the United Nations and expand the kind of remit of the use of force. So crisis in that sense, I think, mobilizes a rhetoric to legitimate actions which wouldn't ordinarily be done, and that is done through international law very often.
So a lot of nodding heads then. Does anyone in the audience have anything to come back on that? Yeah.
And do you think that we're playing to the ISIS's hands when we focus on them, like, because every time we read something, we see ISIS and responsibility. Well, for somebody else, there's no responsibility for the attack. And all these other groups are just having free rides under the radar.
So in response.
I can briefly respond.
Yeah.
So I think that's quite true. So one of the interesting things then about ISIS and the way in which this language of crisis gets deployed, right, is that there's a symbiotic relationship between different groups invoking crisis in different ways. So someone like ISIS would feed off of that language of crisis to give themselves legitimacy. If they've caused a crisis, there's something new and significant. They get attacked more, that creates more division. That's explicitly part of their kind of strategy of heightening the tension, is what they call. So I think there is a sense in which that language of crisis does legitimate various groups who invoke in slightly different ways in order to, advance their agendas.
No, I think we find it. Oh, thank you. No, I think that's highlighted a theme that we will probably continue. So this is where it gets interesting. How would you reflect on the capacity of international law to respond to crisis situations? And then we have a couple of examples: financial crisis, the refugee crisis, and any other specific examples. But after we've just been talking about the language of crisis, maybe have different responses to that altogether. So I think this time I'll start with Greg.
Thank you. I'm assuming this is for recording rather than my ability to boom
Yeah.
all the way across the room. So yes, what's interesting, so we use this idea of doing sort of stimulus. I think one of the things that's useful is back to sort of the more frequent view, which would be thinking about the way in which law restricts the ability to respond to crises. So if we think about something like financial crisis and the ability of states to engage with economic shocks or radical changes in macroprudential regulation, rearrangements of interstate contracts. If you look to Argentina as a sort of paradigmatic example of an economic crisis that is harder to deal with because of restrictions of investment law and actually increasingly trade law as well, you have a situation where the ability to respond is limited. So what happens is you then have action taking place elsewhere. So if we think of the financial crisis, there's a whole raft of new international coordination on financial regulation, which actually pretty few public international lawyers deal with, because it's, that's private law stuff, right? That's commercial law stuff. And so we don't really look at it that much. The reason why that's had to happen in this way is exactly because trade law and investment law restricts the ability of states to respond to these certain things. We set up rules and institutions that are designed to deal with a certain set of circumstances, and then when you're suddenly confronted with something else, things get harder. The perverse actual practice of this is that Argentina gets screwed and everyone says terribly sorry, those are the rules, you signed up to all of these BITs, you can accept Arafat 1,500 claims or whatever it is. But Lord forbid, suddenly we think about EU countries having to do the same thing. We start instituting special sections in all our new bilateral investment treaties. But that speaks more to how I think the restrictive ability of law.
Well, there is not, I feel, so I will skip this question. So I will rephrase the question, which is the capacity of the International Criminal Court to respond to crisis situation, which we mean a massive violation of human rights around the world, amounting to war crimes, genocide, and crimes against humanity. If we look at the literature, academic literature 13 years ago, 15 years ago, you will see how everyone would answer, yes, yes, it is the right answer to all these problems of the world. It will bring reconciliation, it will put an end to other conflict, it will provide victims with rights, which means both participation and reparation rights. Someone also wrote that the SEC was the crystallization of the Kantian ideal of perpetual peace. Then after 10 years, everyone starts to be very critical, a completely different view. You are not cool today if you don't criticize the SEC, in the sense that maybe the expectations that were put on the court were too high. If I have to answer to this question, I think that we should first start to discuss and to question which are the goals of any permanent international criminal tribunals. Can you really think that a tribunal composed by 18 judges in The Hague that are deciding on situations which have taken place thousands of miles far from The Hague are really able to satisfy, to achieve all these goals we have discussed, to put an end to conflict, to achieve reconciliation, to provide historical truth? Is it really their role? Or we should start to narrow down the expectations and also the goals of the international criminal tribunals, and starting and slowly and somewhere from the traditional goals of the international, of a criminal justice system. In that case, we will start not only to see that maybe the SEC is not the answer to the international crisis. This can be very dangerous also because focusing on the criminal justice system, we are just forgetting that there are alternative instruments like Truth and Reconciliation Commission. I see the international community in the last few years investing a lot on the, investing on the International Criminal Court, forgetting that there are other instruments, for instance, to achieve providing victims with truth, as we say this morning. So if I have to go very brutal, I would say that no, the answer is that the SEC is not the answer, is in a condition to respond to the crisis situation, to analyze.
I've been, as an international criminal lawyer, I've been very, very fortunate. I've been able to work with some of these international courts and tribunals. I'm currently in defense team with Ronald Carriage, who was recently convicted of the international tribunal in Zambia. I've also been very fortunate to work with the International Criminal Court, who assisted in Justice Designer draft trial judgment decision in the case, which has emerged from the public. And also recently, I advised the South African Litigation Centre in the case that brought against the South African government in relation to in relation to this Golden Butchard. So I've been very fortunate. I've been able to look at international criminal justice from all angles. What I would say is that as a court, is that at the moment it just does not have arms and legs. The method by which the court is empowered to open investigations into particular situations is, in my view, deficient to this experience. And I think very much Syria is on the fore as the primary example of that. Even last week, myself and a colleague space with a group of students in the Hague. Their local international criminal court has a new promotional deal where it actually surprising is that it has court where it has not abandoned the humanitarian crisis has emerged out of the situation in Syria, and also very, quite interesting, dialogue as well in relation to the situation that I'm investigating. The ICC, of course, faces, in trying to address any type of crisis or new situation, investigation, faces numerous challenges in relation to resources. It has very, very limited budget, has a nice spanking building, but it does have considerable resource issues. And it says no arms and legs either. Canada is, as we see in relation to South African situation, and also a particular issue on Bashir and other states that he's visited, states haven't felt compelled to turn over suspects to support. Of course, the court has no police force, it doesn't have its own police force, which is quite unique in that, for example, the International Criminal Tribunal for the Islamic had a task force and arrests on last issue cooperation with the parties there. And of course, this was one of the biggest indictments of the International Criminal Court of Germany, International Criminal Law generally, is this approach to defense. They're huge in regards to whether, of course, the quantity of arms is properly observed, all issues surrounding resources that are granted to defense teams, particularly where the defendant is not able to afford his own defense, and situations, particularly in relation to the Heritage team, where you have 5 lawyers working with defense and you're against only 40 lawyers in the prosecution. So I think international criminal law as it currently stands and have been able to look at it from, being fortunate enough to be able to look at it from more angles, does not have the capacity to respond to crises. And of course, Syria and Iraq are the embodiment of that.
So I think there we've got a flavour of certain international institutions and how they may or may not be able to respond to a crisis. We'll look at the question again, and for the other half of the panel, I would ask, what do you think about international law itself as a concept, or as, the age-old question, is that an international law, can it respond to these kinds of situations, whether or not you agree that they are crises? And I think I'll push it in that direction.
Yeah, well, I think the thing about international law is that I see it as this greedy discipline, right? That started off with just looking at territorial disputes, and it's like this sort of Pac-Man thing or whatever it is. So I can deal with that, I can deal with that, I can deal with that, and it needs all the different issues and from current affairs up, and says I can respond to that with more law. So the way that international law likes to respond to crises is by saying we need more of this, we need more institutions, we need more lawyers, we need generally we need to grow and grow and grow. So anything that might have been considered outside of the scope of law is then brought within the realm of law mainly by international lawyers who want to stay in their jobs and who want to stay relevant.
Thank you. Patrick, that was not fair. When they were presented, I prepared my arguments about the European Convention on Human Rights and stuff, and you asked me about the international law, which I don't know anything about. So I will ignore your question and we'll talk about the European Convention on Human Rights and the European Court of Human Rights. Actually, I have an answer for that question. So basically, can the European Court of Human Rights deal with a crisis? And my question is no, right? And moreover, I think that they shouldn't even attempt to do anything because it undermines their legitimacy. Why? Because judicial role is predominantly post factum, right? You deal with the consequences of the crisis, not with the crisis itself. I will give you an example. Russia occupies Crimea and, supports or somehow deals with these republics in Donetsk and Lugansk. What the court does in this situation, the court issues interim measures, saying to Russian authorities that Russian authorities shouldn't violate the European Convention on Human Rights. Okay, let's imagine Vladimir Putin in his office, thinking about how to occupy another part of Ukraine. At some point, there is a call from his secretary saying, look, the European Court of Human Rights issued an interim measures saying that these actions are illegal. You would say, oh, really? I didn't know that. Now I know. Let's stop. Let's roll back and imagine that it has never happened. Otherwise, we would be in trouble because the European Court of Human Rights is saying that. It makes very little sense. So I think that the fact was that these interim measures of the European Court of Human Rights are effective or not, it doesn't depend on the legitimacy. It's purely political issue, and I don't think that the court should actually even interfere or intervene in this situation. When the crisis is over, then it's for the court to decide whether there were any violations. Now, during the crisis, intervention happened in Ukraine, I don't think that court should actually even do something. I know that I didn't answer your question at all, but at least it's somehow connected to the question.
No, I think it definitely did, because obviously the European Convention is formed and it's natural.
These days, Italy is supposed to be aggressively pressing it, not going.
Oh, that was a really great
Well, and also, if you didn't answer the question, is that not in the great traditional question, right?
Well,
I'll try and answer the question. Okay, so before I answer the question, one thing I want to say that we might want to think about is that when we talk about this capacity to respond to a crisis situation, that in a sense assumes that a crisis is this neutral thing and gets resolved and it's good. But in actual fact, crises can be resolved in multiple ways, sometimes favoring some interests and sometimes favoring other interests. So for instance, what Greg said here about the financial crisis in Argentina, for some people that really did resolve the crisis. For the creditors in the American banks that lent money, imposing austerity on Latin American periphery is a resolution of the crisis. So one thing when we think about this idea of international capacity to resolve crisis, and maybe the kind of decrying inability to resolve crisis, on whose half is the crisis being resolved and for what reason? So I think one thing that international law then is particularly good at is resolving crises in such a way that they basically keep things the way they are, benefit the powerful in various ways, and divert the crisis into a way that keeps things bubbling along but doesn't change things fundamentally. So if we look, for instance, at how the Paris negotiations went, and what we came out with in terms of climate change, the emissions trading schemes and things like this. So what we have is a kind of way of converting what really needs big solutions into a way that fundamentally upholds the status quo. So I think one thing, international law is actually pretty good at responding to crises, but in a way that isn't getting at those long-term problems and is essentially helping some powerful interests to stay powerful. The other thing about this question I think is important, particularly in terms of the financial crisis and refugee crisis, is sometimes when we ask this question, we forget about the role that international law has played in constituting the conditions that give rise to the crisis in the first place. You couldn't understand the refugee crisis unless you understood the territorial divisions directed by international law, particular obligations that are created by international law, the legal arguments that people use to intervene. So just saying, oh, what does international law have to say about the refugee crisis and kind of resolve it, ignores that role that international law has already played in creating those conditions of crises. So one of the problems with international responding to crisis in this way is that it's always in there creating those crisis conditions in the first place. Just one of the reasons why thinking that it's being a presto quick fix is a bit of a problem. So yeah, I think
okay, so that's essentially coming back to our first theme. Crisis is a waiting time. International law solves problems in response. I just noticed the hand up, Mark.
Yeah, so this is a question for everyone, anyone can answer this in particular. So if you do perceive international law as being a crisis or even a convention law, do you feel that there's been a bit of a retraction in itself? Because the general feeling which I get from you guys is that there's almost a loss of self-confidence the regime as a whole, and there is moving away from, as you were saying, this kind of like this will solve everything kind of concept. So almost utopian, and it's going into more apologistic direction. I would say I thought your response is quite positive for the Russian state, very much in that it's well, we can't do anything, so we should. And you feel there has been a movement in that direction.
So, do you feel that there's been a movement in that direction? Just keep it the microphone. Well, no, I'll come back.
Well, I don't know, like, maybe we're just a bunch of pessimists, like, who are not seeing, like, the obvious beauty of international law. Or I love the European Convention of Human Rights, don't get me wrong. And I don't really like Putin. I will never get access to Russia again. Anyway. No, I think, you know, like, it's our role to question. You know, like, it's our role to see the crisis where maybe there is no crisis. And then, like, build our imaginary windmills and then trying to fight with these imaginary windmills. And I don't think that's, well, obviously we are living in it is very obvious that we are living in a situation that there is a lot of human rights skepticism, a lot of international law skepticism, especially in this country. Look, you need like open Daily Mail, and here it is. Like a lot of like crisis is in there, but how to solve this crisis? Well, that is a $100 million question. Like, nobody, if I knew, well, I would probably already publish something. Like, I have no idea. But international law, I agree with Rob. Like, it is such a broad area that, like, a lot of problems that we're trying to solve now are preconditioned by international law to begin with. And we're using the same tool that created problems to solve these problems. That might not be the best of the approaches. But I'm very optimistic. I think the European Court of Human Rights has overcome so many crises in its history that I think this tiny little issue with prisoner voting, it will be one of the, like, it will be solved within the next 50 years.
Sorry, can I just jump in? I mean, this is a quick example. I think also there are times when there's a perception of lack of ambition, and then there's actually something quite different going on. So, for example, when WTO came in after the Uruguay round, everyone was quite shocked that it was ever agreed. I mean, hindsight now, it's amazing that happened. So then you've got, I mean, essentially, pretty much everybody is a member. You know, you've got near universal coverage. And it looks like it's not going to happen, we're not going to conclude a new round, and everyone's terribly sad because they say multilateralism is dead, there's no ambition to conclude a really meaningful giant package. In practice, what is happening is huge amounts of activity with trade negotiators, negotiating agreements that are liberalizing services in particular in a way that was never even dreamt of during the Uruguay round. A whole host of other things that have been packaged in. And then, you know, we have a separate discussion as to the benefits or disadvantages of that. But it's interesting that this sort of the seeming lack of ambition actually in practice isn't happening at all. The trade negotiators are still busy. They're just not busy, like I was just saying, they're not busy in Geneva. They are busy in Geneva because the negotiators still happen there. So TISA, which is the Trade and Services Agreement, is being negotiated there, but not in the WTO. But everyone has meetings in meeting rooms around there because that's what it is. So it's sort of this weird, the perception of the effect. And I wonder if that's actually, frankly, somewhat intentional.
I noticed, yes, Ben.
Yeah, sorry, back to council.
I invited this over.
Also, what Prof was saying as well, and how we were talking about defining crises. And you just said, if I understand correctly, that sort of ECHR should be getting involved in ongoing crises. And I mean,
depends how you define ongoing crisis.
Exactly.
Yes.
So I just wanted your thought. I used to live in Jordan, so I just wanted your thoughts on should they have you getting involved in situations in Georgia where, for example, crises are being perhaps intentionally continued.
Oh yeah, Georgia is a great example. Georgia is a big failure of the European Court of Human Rights. Like they also issued this beautiful interim measures which nobody cared. And like when a court issues a Well, they said that it's binding. Well, when the court issues a binding decision and it's not complied with, it is a huge blow into its legitimacy. So if you don't care, but like if you just like making a noise, what's the point in that? So like in this Georgia v. Russia campaign, like the court issued very precise interim measures during the conflict. Nobody paid any attention to this interim measure. That's it. That's the end of the story. So like it is not the role of the, well, I care a lot about the preservation of the system, like of the European Convention on Human Rights, how it is. And I think that the court's involvement in these particular scenarios is very damaging to its reputation. It's damaging to its reputation. And next time, the court issues interim measure in an individual case where it's supposed to issue interim measure, nobody will care about this interim measure because it was not complied with by Russians in the Georgian Russia case.
Okay, George, welcome back.
Yeah, it was just from that point, I was going to ask the panel, to what extent then, given, I mean, recent drug support for Brexit or against Brexit, it's been quite enlightening to me in terms of people's lack of understanding of what these regimes or what these systems have done. Is the crisis actually international law and international human rights law just trying to prove its legitimacy? And to what extent can it do that, or to what extent will it be a crisis for testing time, as far as I was concerned? When does the test end, and does it break down? And what will the future then be? How could it be resolved?
It's a really good question. I'm not sure.
If you're not tired or
I think there's a similar themed question next. I'm not sure what order the slides are in, but I'll check. Does international criminal court suffer from a legitimacy crisis? So kind of like, if so, is this justified? I think we'll start with this side of the panel. Maybe think about that general idea as well. Or any other international institution that might be into your research.
My main argument about the international criminal court is that perhaps Rome statute was a bit obsolete when it entered into force back in 2002. I think it hasn't. I'm of the strong view that the international criminal court in particular, it has only the capacity to respond to particular types of situations, particular types of state and non-state actors. So, for example, the international criminal court can only prosecute, it can only go after individuals. So what about our multinational corporations or private security military companies? What about the armed group itself as a collective entity? We can put ICJ, we can put states responsible for particular acts. We see in relation to the obviously Bosnia versus the Serbia case. But the international criminal court, I think the drafting of the statute laws are a very, very valuable opportunity to view activities within it. And I suppose with the legitimacy of the court, well, it doesn't have a jury. Accused individuals, they're not entitled to be tried by a jury of their peers. As I said previously, it doesn't have a police force. The resources available to the defence team are arguably minimal, to say the least. And I think, in particular in relation to the International Criminal Court, it has this whole issue concerning its legitimacy. Why does it exist in the first place? And it all starts before the view that the International Criminal Court is deliberately picked on African states. that argument has its considerable flaws. You can have read the website, the situation of such a background of situations with the sort of development case, etc. You can pick holes quite readily in the argument. But I think as well, you know, the states, the minority states that have signed up to the statute, they don't have particular, they don't have humanitarian violations on their territorial borders. It's the problematic states like Syria, arguably India, Russia, the big one, the United States, you know, that aren't within the jurisdiction of court whatsoever. So I think ultimately, yes, at the very start of the 21st century, we looked at the International Criminal Court through very rose-tinted glasses. We thought this is wonderful. Now we have a successor court to the Nuremberg Tribunal and the ad hoc tribunals, but I think over time has obviously eroded because of numerous controversies involving the office of prosecutor in particular. So that would be my take on it.
Yeah, thanks. Well, I think what we already answered so far, mostly in the panel. First of all, we should question the concept of legitimacy, and I don't think we have time to do this today. First of all, let's start from the conclusion. The answer to this question, I think, is yes, and we already said it before. Who has undermined, that's the question, the legitimacy of the International Criminal Court in these 15, 16 years? Almost everyone, all the actors involved in the work, in the practice of the ICC, from the prosecutor, the office of the prosecutor, the different offices of the court, and the state parties to the wrong statute. We have said it before again, why starting from the prosecutor? Because, again, in part I agree with you for many things, but I think that the main critique raised against the court, which undermines the legitimacy to be an African International Criminal Tribunal, is still very important. And not because serious international crimes, cold crimes have not been committed in Uganda, in DRC, in Kenya, most likely, but just because for the, let's say, the poor reasoning provided by the prosecutor, not opening investigations in other situations. That's the reason for which, and we go back to the concept of legitimacy, the perception that external actors of the ICC have of the International Criminal Court is a court that is opening investigation in situations which are not problematic for powerful states, or they don't create any problems, or at least are supported by powerful, like in the case, for instance, of Libya and the referral of the Security Council. This is not the only problem. We have seen this before as well. What has undermined the legitimacy of the ICC? The length of the proceedings, the lack of cooperation by member states, the difficulties in getting evidence. And again, as we said before, Kenya is the most emblematic case in this regard. After many years of investigation and economic resources, financial, which have been spent on the situation, the prosecutor has had to withdraw the charges against the president and the deputy president of the Republic of Kenya. Does this affect the legitimacy of the International Criminal Court? Well, I think the answer, I mean, it's, we can get the answer quite easily. And we go back to the question we asked before, just in 1 minute. I'm too pessimistic. Maybe from a Gramsci perspective, yes. Am I proposing the abolition of the International Criminal Court? No, the answer is not that. I mean, I don't think that the world would be better without the establishment of a permanent international tribunal, even with problems related to its own legitimacy. Our role in this regard, as scholars, practitioners in international law, is to find ways, to propose ways in which the law and practice of an institution like this, which is still very young, can be improved. Also, the building up bridges with people which are involved, who are involved in the work of such institutions. I was too long.
Okay. I think, Christine.
Just I'm not going to say anything about the ICC. So But I thought a really interesting issue that you raised was the question that sort of ties in with the state of exception, right? If we've got a constant crises, is there an end to them, and can there be, is there a resolution, right? So I think that is a really important question. It reminds me of something I read recently, which I thought was really convincing, by Samuel Moyn, in which he writes about the endless war, or the forever war, in which we're in, that the war on terror is cast in a way as this constant crisis, and all that international lawyers then do is not to actually resolve this crisis, but to sanitize it, right? So all we're doing within the crisis is fiddling with technicalities, but we're not actually thinking about structural changes. So I think, and that really resonates with me.
Thank you. I just want to some hands go up during that. Yeah.
Yeah. Actually, I have a few comments on this, but I'm going to be very short. I mean, I think we have to assess the deterrent effect of the ICC or international criminal justice in general. I mean, here I missed the question, but it was before that is the effect of the international. Can you put the question that was before? Legitimacy queries. Of course, if we open the newspaper and we see that there might be violations of human rights on ILHRU everywhere, and suddenly we see the investigations that will open at the ICC, of course, we say, or most of you would say, this is not working. But we have no idea if this actually has a deterrent effect in the field for the military commanders or for the people who might be committing these breaches. The other thing is, I mean, we should not, I think like the other important issue is that it's complementary to the national systems. And nowadays, for example, a convention for crisis against humanity is being discussed in the ILC in order to strengthen the measures and the mechanism within the national systems, even before getting to the ICC. So I don't know, this is something that I guess it's going to be developed in the next few years.
Okay, thank you. Now, we're almost running out of time, but we have one last question, which I think we'll do a quick fire, if you can make your answers as short as possible, but also impactful. Great. Placing the discipline in its historical context, is international law and or human rights law in crisis? Now, obviously we discussed this over the panel, so I think we'll start with Rob first.
So if you want the short answer to the historical question, move it on.
From medieval.
Okay, this is a difficult thing to have a quick fire response to. Right. One of the things I guess we should think about is that if you want to think about international law as having popular purpose or popular legitimacy, that really only comes about in 1945. It stops in about 1979 with the failure of the International Economic Order, and then it comes about again a little bit in the kind of post-Cold War messianic things. So generally, international law has not been something that had some huge amount of legitimacy or popular weight. Quite the contrary. So I think in that kind of long historical durée, I'm not sure that what we're seeing now is anything particularly different or distinct from how it was before or how it has been. I think international law's kind of popular legitimacy is the aberration largely, and it's generally just a technical thing that's done by state elites in closed corridors, which I think then comes back to this thing you're talking about Brexit, which is that one of the things that people have a problem with, I think, with international law in general is that there's no sense of their own popular sovereignty or control over the process of international lawmaking, whether that be nice things like human rights or nasty things like trade agreements. People generally feel like they are estranged from those processes. But that's kind of common historical feature of international law.
This is history. Now, it's fine. The European Court of Human Rights has never been more influential. The European Convention on Human Rights has never had so many contracting parties. It's 47. It spreads between, I don't know, Vladivostok and Reykjavik. And there are 800 million people that can apply to the European Court of Human Rights, so it's fun. The problematic issue is that basically there is a little bit of backlash or pushback from the corrupted parties to this point. However, we shouldn't forget that like throughout its history, there were like so many attempts not to comply, to question the legitimacy of the courts, question the legitimacy of the judges, and the court survived, right? The court survived, and I'm sure that the court will survive. If the court is closed tomorrow, like, don't blame me. Thank you.
So it depends on which. Right, this is not going to be true. So it depends. Actually, I don't think that the discipline is in crisis from the perspective of the number of people dealing with it. So I think it's actually thriving from that perspective. What's problematic is that it likes to see itself as part of this, what's been called the Whiggish progress narrative, that we are constantly on a path of progress and have overcome difficulties in the past with the instruments of law and international law. We've built institutions and so on, and therefore we are always bettering ourselves. So if we start with the Third Reich, for example, that was the really bad part then, which happened in Europe, and then we overcame that through Nuremberg, and then sort of now mass atrocity has, according to this progress narrative, moved into Africa and away from the centers of power and so on. So I think that is deeply more problematic about international law and how it views itself and how it views itself as overcoming crises. But from those centers of power, I think it's actually a discipline which is thriving.
I suppose, as an international criminal lawyer, and talk about the ICC, every institution is going to have its preference versus sandwich, it's not going to be all complete over even digital stores. I think, as a court has some challenges, say, it has had a lot of successes recently. It has also had to take a couple of steps back as well. So I think with regard to a path forward for international law, international law generally, I think you could say that there are encouraging signs and that the African Court of Human Rights has established an international criminal law wing. We also have the establishment of a new Kosovo special criminal court, which will take up residence in the former ICT-wide building. So there still seems to be this, within the international community, this idea that we still need these court systems in place. Now, ultimately, it remains to be seen what will happen with the situation in Syria. So we're not going to talk about whether there is establish a new court to deal with Syria, and of course something would perhaps fly in the face, would be a slap in the face for the international court, arguably, the best phrase to use. But I think, it can be, and there are a lot of challenges. We can be a little optimistic too. So I'm somewhere in between, I think. Somewhere in between.
I'm so surprised it's on the face. On the ICC.
Because there has been the US Security Council has failed to address the situation directly to the ICC.
Why is this on the face?
I think it's stuck in the face in the ICC, I think. That would be one view. That is one of the three mechanisms that is in place to refer a situation to it. And ultimately, of course, Russia is one of the states veto that resolution, of course, has its own interests, to preserve its own interests in our conflict situation in Syria. But I think it does highlight some the stumbling blocks, the challenges, how international criminal law looks on the outside, and looking in and thinking, well, you're just moving around in circles, really.
Yes, just one attenuating circumstance for the International Criminal Code, I would say it's the anti-tribunal. So I would like to withdraw the critics raised against the European Court of Human Rights, which today is considered as world champion in the protection of human rights when it was only 14 years old. So of course a bit of optimism you are asking. Let's give time to this institution. But the optimism comes out when we move from the institution, I think, from the legal field. Is international criminal in crisis? No, I don't think so. The answer is no. I mean, we have assisted the last 20 years to the hugest development of this of international criminal law, not just looking at international sources which have been developed, but also at international institutions. Just 20 seconds to say that what historically, traditionally were defined, were put in place under the umbrella of national sovereignty and referred to massive violation of human rights, today they cannot be put in place anymore thanks to the development of international criminal law under this national sovereignty, but now they amount to genocide or crimes against humanity and when it comes to migration. So this is before I say it's not time to go back, it would be a political decision to say, okay, let's get rid of these international institutions. International criminal law has been developing significantly in the last years, and I think this is a good sign and a good direction we should take also as scholars.
Extremely briefly, because Chrissy basically used the word that you stole the Whiggish from my mind. It's exactly that. The only thing that's in crisis is our smug Whiggish hip-hop narrative of everything keeps on getting better, you know, but it's Triestino, Peace of Westphalia, and then you go each time, activistic war, things get better. And then now it's all brilliant because we've got these other institutions. The practice is there's lots of other problems. They're just new problems, they're different problems. It's easier, isn't it? You know, nothing new under the sun. We're just facing new stuff, but it's no more problematic than it used to be, or better or worse. It's the way we describe it, I think, is the bigger problem.
And that's very, I think that's very good panel. Do we have, is the room?
Yeah.
Yes, we do. Okay, so I had a bit of a crisis this afternoon with the panel. The wine almost didn't arrive. So I'd like to thank our panel, first of all, for an interesting question. There will be refreshments down in the foyer, and we will see you tomorrow for day 2. Thank you everyone for today. I think we probably should stop and remember that we do have dinner as well. Istro, Jax, we will show you